morning, madam. But actually, there was an item, madam, on the last day, the PP short time as per order, madam, that it will be, case that it will be necessary and we need some time. So I don't know whether there is
Item number
7, madam.
7.
Item number 5 to madam.
Then we'll have it on another date. He has
I-
just received
That
it
is what
today.
I have today morning I have received it.
That's I heard you say.
Is worried, madam.
When do you want it, Mr. Kaman?
Yes, madam. 7. I'm in 7, madam. I don't know 10. 5, 6, 7, 8.
All the councils are here.
Yes. Yes.
Mr. J. Kaman, Learned Senior Counsel in item number.
7.
You are in 7.
Yes.
In criminal petition 157/2018, assistant J. Kamar assisted by
Statement part of the date show.
Mr. Kamar, can you ask the juniors
Yeah.
to give a appearance slip? Then she will put it for all the petitioners along with the petition numbers. And Mr. P. Bhattackur, Learned APP submits that he has received the case diary as called for today morning and accordingly seeks some time to go through the same. Prayer is not opposed. Relist, yes.
List it after being vacation. In the last week.
Yeah, okay.
In the last week. In the first.
2nd May. 2nd May.
Oh, you're fine. Much of that. I take leave, my love.
All right,
I'll
all
keep
right.
the list.
Yes, please.
From 5 to 8, 5 to 8. Sir, please, your lordship. Lordship, I beg to mention item number 18, lordship. Lordship, here in this matter, we tried to contact 18, lordship.
All right.
Lordship, here in this matter, we tried to contact the price, but we're not able to contact. We tried to reach this, but we were not able to reach. We have lost contact.
So then you take appropriate steps.
We'll
Registered post letter have you sent?
no, lordship, we have not. We'll try to contact. At the same time, we prefer some time, lordship.
I'm giving you time, but you, in the meantime, you issue a registered post letter to the client.
Lordship.
And it's a criminal revision petition. What instructions do you need?
Lordship.
It is
Already
for
they are-
hearing.
And that's
Anyway, I'm accommodating you today because as it is, I'm not sure how much the hearing matters can be done today. Mr.
S.A. Bhaktiyar.
S.
A. Bhaktiyar.
As prayed for by Mr. S.A. Patel, Learned Counsel for the petition,
Petitioner.
with consent from the other side, list this matter after 2 weeks on such and such date to enable the petitioners to contact the clients with whom they have lost touch as the matter pertains to the year 2012. It is needless to be clarified that
Lordship, interim is date.
interim may finish and continue to the next date of this.
Lordship, let us say 2 weeks time. Much of this. Maybe. If you consider other side, I bet you that number 23 meter. Hearing. Come after 3 weeks.
As prayed for by Mr.
H. Brahman.
Ajat Brahman.
S. J.
S.J. Brahman, Learned Counsel for the petitioner, which is not opposed by the other side, relist after the Jakarta dates on such and such date.
Please, your lordship, item number, I beg to mention item number 9.
9.
My senior is suffering viral fever. Matter may be decided after due vacation.
As prayed for by Mr.
On behalf of
Your name.
H.
As prayed for by Mr. A.
H.
H. Ali, Learned Counsel for the petitioner on the ground that the conducting counsel, Mr.
A. Shoikya.
A. Saikya is A. Shoikya or A. Sharma?
Anupam. A. Sharma.
You don't even know the name of your senior. What is this? You are making a mention on the behalf of a senior and you don't even know his name. Sorbet state of affairs, I must say. Mr. A. Sharma is indisposed and accordingly seeks time. Prayer is allowed. Relist on such and such date.
Please, lordship, I beg to mention item number 27, lordship.
20.
27, lordship. I'm for the respondent, lordship. I have taken consent from the petitioner side, lordship.
You are for the respondent.
Lordship.
As prayed for by Mr.
A. Hassan.
A. Hassan, learned counsel, for the respondent with consent from the uh, petitioner, relist after the update on such and such.
Lordship, there is an interim order.
Interim, if any, shall continue till the next date of listing.
Effective item number 22, Lordship.
20,
22, Lordship. Kindly adjourn for today, Lordship.
as prayed for by Mr. But have you you are for the petitioner?
Yes.
What about the respondent lawyers? Have you taken consent?
Yes, Lordship, I have clicked motion.
Your name?
Yeah, Muslim Lordship.
As prayed for by Mr. M. Hussain, learned counsel, for the petitioner with consent from the respondent counsels, relist on such and such day.
My lord, item number 19, I want to withdraw, my lord. I am on behalf of S. Silver.
19. Mr.
K. Kolita.
K. Kalita, learned counsel, for the petitioner, submits that he has received instructions from the petitioner that the petitioner does not desire to press this criminal revision petition and accordingly seeks withdrawal of the same. Prayer is allowed. Criminal revision petition stands dismissed on being withdrawn.
Okay.
Give Mr. Borthakur the appearance, sir.
Just referred this criminal revision against the judgment and order dated 3/3/2025.
Page.
Order is at page number. When is at page 48. This, yeah. It was upheld it. Lots of one.
This is the order is under 138. Where is the order?
Order, the trial court order is at page 48. Sir, appellant court's order is at page 72.
So you're challenging both the orders,
The appellant order,
appellate order, 3/3/25.
20.
Where is it?
it's in page 72.
Seventy-two.
72.
Yes.
Lordship,
Operating part.
should operate for okay, it upheld it the previous decision only. Out of a check of amount 4,75,000, it has issued an amount of 9,50,000 and for 7 months of imprisonment.
Well, I'm issuing notice and I will, and the interim shall be considered on the next date.
Lordship, I have heard that NBW has been issued.
This is of three.
Level 2. Kindly till next date interim.
Not like this.
Lordship, there's one valid point I'd like.
What is it?
Lordship, if you kindly peruse page number, if you kindly peruse page number 33. Lordship, the complainant has stated that one of the loan transaction he has taken from one National Bora. And the money received they have exhibited, it is of 21st day of August 2026. And your Lordship, you kindly peruse for page number 40, that is the cross of the complainant, W1. Here, the complainant himself have stated that the accused person promised to.
You see, this is the third court. Concurrent finding is against you.
Yes, Your Lord.
There are evidence.
Yes, Lordship.
Now, the sufficiency of that evidence, this court is not going in an event, in an eventuality, if the findings of the trial court as well as the appellate court was based on no evidence, then of course, a third court can look into it, or if it is contrary to law. Now, evidence is there. If you want me to reject your interim, I can do it right now. If you want me to reject. Instead, I'm saying I'm issuing notice and I'll keep the interim open for the next date. Mr. Heard Mr. T. Majumdar, Learned Counsel for the petitioner. This criminal revisional petition is directed against the judgment and order dated 3/3/2025, passed in criminal appeal number 54/2024 by the additional session judge number 1, Kamrup Metro, Guwahati, whereby the judgment and order dated 4/4/2024, passed in CR case number 5274/2018 by the Learned Court of Judicial Magistrate First Class Guwahati under section 138 of the NI Act 1881 was upheld. Issue notice, returnable, give a date after 2 weeks on such and such date, and registered post AD within 3 days. That's the post AD within 3 days. List after list accordingly. Date the the interim prayer shall be considered on the next date.
Criminal revision petition.
Yes, what is the error?
Error being is law to be that in the appeal, we were not given a chance of being heard logic.
In the appeal.
In the appeal logic. Order prosecuted finding.
Who are you?
I'm Nagara Brahma, alias Nagara Boru. I'm the appellant.
You are the accused.
Yes, Lord.
How many accused?
Only one issue.
One accused. Where is the appellate court's order?
Appellate court order is page number 38.
Yes.
I was convicted under section 326 of IPC, Better Learned Court of CGM, and I was convicted and sentenced to undergo imprisonment for 1 year. Therefore, we have filed it in an appeal.
The appellate court has discussed.
Yes, nothing in case number 41, and it's in the paragraph. Paragraph 5.
Paragraph?
5.
None appeared for appellant 1.
What happened on that day? We have filed our Hazira, and as we have other cases also, after filing the Hazira, we went to other courts. And after returning that,
Filing of an Hajira will not excuse you from not appearing.
it was not our intent.
And just simply filing the appearance and then going away does not mean that you have appeared.
But what happened? After filing the Hazira, we moved to another court also. We have other cases. So after concluding the cases, we returned to this court. And till then, the court has raised notice. And we thought that another date will be given.
How can this appeal be, the revision petition can entertain all this now?
We admit that.
All right, notice, nothing more.
Motive, I have IA also.
IA for?
IA is for suspension of the order.
I'm not considering now. Let us have the trial court records, the case records first. After receipt of records, the prayer for your IA shall be considered. You are Mr. Heard Mr. K.K. Henrik, Learned Counsel for the petitioner. Also heard Mr. P. Borthakur, Learned APP for the state respondents. This appeal, this is an
Criminal revision petition.
this criminal revision petition is directed against the judgment and order dated 4/3/2025, passed by the Session Judge Kamrup M. Guwahati in criminal appeal number 24/2024, whereby the conviction and the sentence passed by the Chief Judicial Magistrate Kamrup in GR case number 9240 of 2011 under section 326 IPC was upheld. Issue notice, returnable 3 weeks. Mr. So-and-so accepts notice on behalf of respondent number 1, extra copies within 3 days. Registered post AD in respect of respondent number 2, steps within 3 days. Let the case records of both the trial court as well as the appellate court be called for through the registry. List after 3 weeks on a date to be fixed by the registry. The connected interlocutory application being IA Criminal 331 of 2025 shall be considered after receipt of the case records. We'll make it together.
What are dated, my lord? 18/1.
Just one sec, Mr. Bhattacharya. In the IA, no separate notice is required because I have combined both and given it. It will do, right?
Your notice is 39, my lord.
This is order dated 18/1/25.
Yes, my lord.
Domestic violence.
Domestic violence, by which the petitioner has been directed to pay maintenance the rate of rupees 4,000, my lord.
4,000.
Yes, my lord.
Only notice.
Next, my lord, the petitioner, my lord, he does not have anything, my lord. He's single,
4,000.
my lord.
Notice.
He's a daily laborer, my lord.
Maybe, but that
Daily
doesn't,
labor.
that
Daily
doesn't
labor.
discharge the liability of a husband to maintain his wife.
Notice, may go, my lord.
Notice will.
Yes.
This is item number 3.
Yes, my lord.
Heard, Mr.
Yes,
S. Islam, learned counsel for the petitioner. Also heard Mr. So-and-so Bhattacharya, learned APP for the state respondent. This criminal revision petition is directed against the order dated 18/1/2025, passed by the jurisdictional magistrate court in DV case number 103/2022 under section 12 and 23 of the Protection of Women from Domestic Violence Act 2005, by which the petitioner was directed to pay maintenance allowance at the rate of rupees 4,000 only per month to the aggrieved person. Aggrieved persons. Stop. Inter area credit, huh? Issue notice returnable 3 weeks. So-and-so accepts for R1, R2 register post AD 3 days. List after three weeks on a date to be fixed by the registry.
and then interim prayer, that may be considered.
The interim prayer shall be considered after on the returnable date.
Obliged.
Yes.
Noted.
302.
Noted.
302 offense.
Yes, Lord, yes.
Yes. Concurrent findings.
No, no, the charge.
Oh,
Charge is
charge.
same. I am coming against the charge, Lord.
Yes. So, framing of charge.
Yes, Lord.
Where is it?
Yes, Lord, Annexure 5, case
Page,
number
page.
44. 43 and 44.
3.
43, 40.
Yes, please read.
That's it.
Please read.
Accused person to ensure are present. On perusal of order dated 19/12/24, it appears that charge under section 341, 302, 34 IPC has been framed against the accused person, but on perusal of the materials available on record, it appears that charge is required to be altered. In view of the above, heard both sides and on framing of alternative charge, upon hearing the submission of the learned counsel for the accused person and the prosecution in this regard, and considering the materials available on record, this court, by exercising power under section 216 of CRPC, altered and framed fresh charge against the accused person, so and so, under section 341/34 and 302/34 IPC, and kept with the case record, the contents of the alternative charge is read over and explained to the accused person, so and so. And one PW, namely Surajit Sinha, is present, but he could not be examined due to alteration of the charge and allowed to go back and perusal of the petition for adjournment. That is ultimately
This is
issued,
altered.
altered, and 302, 341/34.
Earlier, 19/12/24, that was the first order, under which 341, 302, 34 was.
Same section, Lordship.
Then why
How-
altered?
Why altered, Lordship? That's
is altered?
another matter will come later on, Lordship, because there is the same charge, probably the construction of the charge from the judge uh, thinks that it is not proper. So the same charge was framed, Lordship, 341/34 and 302/34. What I am on is that, Lordship, this is not a case of homicide. Lordship, my learned public prosecutor is certainly agree that the basic requirement of charge of murder is to prima facie establish that the death in question was homicidal in nature. So, without going through the oral statement, I will certainly, if Lordship allows, I will certainly go to the oral statement, but that will come later. I will show two documents of the prosecution, which will show clearly that this is not a
Mr.
case of.
Counsel, Mr. Ullah,
Yes.
how this court is going to examine all this at this stage? This is charge framing.
Lordship,
This
Lordship,
test
this-
is to see the materials as it is. And if a prima facie
yes, Lordship, yes,
offense is
Lordship,
made, that's all.
yes, Lordship,
This
the
court is not
materials.
going to test whether these averments and these materials are true or not true. That is
And
not going to be done at this
Yes,
stage.
Lordship, that not I am saying that, Lordship. Available materials on which this charge is framed, I am saying that there is no any materials to
Where
prima facie
is
preview.
the FIR?
Yes, Lordship, FIR is at page 19, Lordship.
Page 19.
From page, Lordship. From page 24, it is the translated version of Lordship.
Page 24.
Yes, Lordship.
Yes, please read.
Yes, Lordship. With due respect, I beg to state that on 26/5,
You are for which accused? All.
all Lordship. My brother Sanatamba Sinha went out from his own house to go to Old Market. Thereafter, in the night of the say 27/5/23 at about 1 p.m., the local people informed us over telephone that the aforesaid accused person confined my brother Sanatamba Sinha on the allegation of stealing fish in their phone. Immediately, my brother recovered with a grievous bleeding injury condition from the custody of the accused person with the help of the Baskandi police, and immediately the Baskandi police authorities sent my brother to Alipur hospital. The doctor BMC, after observing the dying condition of my brother, immediately referred to Silchar Medical College. My brother died on 19/6 after 24 days at Silchar Medical College. While undergoing treatment, it may be mentioned that the result of the assaulting my accused person, my brother's right hand and left foot were broken and received severe bleeding injury on head, and my father
How
was,
can this court at this stage determine whether this is homicide, not homicide?
Lordship,
I'm
I will
issued
kindly refer to
notice right
Lordship,
now
Lordship,
and,
Lordship, refer to two documents.
Mr.
Lordship.
Counsel,
Lordship, prosecution two document only
sorry,
page number 42,
I'm,
Lordship.
let the case records be
Lordship,
be
the
called for.
medical document and postmortem.
I
the
will
cause of death.
consider your interim prayer after going through the case record.
Lordship, yes, I do admit, Lordship.
Sorry,
Kindly go
heard
to page
Mr.
number 42,
Tarak
Lordship.
Ullah, learned counsel for the petitioner, also heard Mr. P. Thakur, learned APP
Lordship,
for
it
the
is a
state
case of heart attack. It is clearly given by the postmortem report and the
Not-
medical
not-
certificate.
Mr. Counsel, the allegations in the FIR are serious. At this stage, whether it is because of the heart attack or because of the injurious, these things has to come out. You see, you have to appreciate this is at the framing of charge stage.
Lordship, for the framing of charge,
This revision petition is directed against the impugned order dated 10/3/2025 passed by the Learned Additional Session Judge number 3, Kachar, Silchar, whereby charges under section 341-302-34 of IPC was framed against the petitioners. Issue notice returnable 2 weeks. Mr. So-and-so accepts for R1, for R2, register post AB 3 days. This case records will come from the court.
Yes.
Scan copy,
Can-
otherwise, let the scan
Lordship,
copy of
as
the
to-
case records be called for through the, from the Court of Additional Session Judge number 3, Kachar, Silchar, through the registry of this court. The interim prayer shall be considered after receipt of the case records, a scan copy of the case records. List, I think, 3 weeks, list after 3 weeks on a date to be fixed by the registry.
Number 32.
If this is that case,
Yes, my lord.
you are for,
Lordship, with permission of my senior is already waiting, my lord. Lordship, this comes against the order of Naradi petition being rejected. my
yes,
lord.
yes, I have heard, Mr. Chaudhary.
Yes, yes.
Mr.
my lord.
Vaidya, I'll come to you, but a very important aspect of the matter has been brought to the notice of this court. It appears that the first time FR was submitted,
Submitted.
which the court has gone through and saw that the 164 statements discloses incriminating circumstances and ordered for fresh investigation by a different investigating officer. That was done. Interestingly, the CCTV footage which the complainant has stated in her statements, the investigating officer has issued a notice, no? A notice that you produce all that. How is the informant going to produce the CCTV camera of Radisson Blue located at Goa? Is that the job of the complainant, Mr. Vaidya? This is a serious issue.
Lordship,
I am not on the merit or anything, whether there is materials, not materials, but if this has come in the statement of the informant, is it not the duty of the investigating officer to collect the evidences? Or it is or the investigating officer is going to now tell the informants, you go and produce all this? What is this?
my lord. Lordship, if I may submit now, my lord, I'll just submit one line, my lord, in this regard. my lord.
Mr. Locker, what is this?
Yesterday, Lordship asked me to call for a KJ from the office. Or OC Lordship, this could, then.
They are all before the CJM court. So then tomorrow can it be through registry if we say scan copy? It will kindly like I have a person. Then on the reopening, Mr. Chaudhary, yes, what is your submission?
My lord. Lordship, if it's. a
And you are
FIR,
for
my
whom?
Lordship, the alleged accused person, my lord. The alleged accused person. Lordship,
I don't think you have any role to play at this stage.
Lordship,
Anyway,
the moment it is filed, my lord, if I may interrupt, my lord.
Yes.
The Lordship was. Lordship, till the moment the case is in the investigation stage, till the FR is submitted, or if a Naradi petition is also submitted, and on that also an order is made by the learned trial court, my lord, I do not have a locus to stand, my lord. The moment, my lord, a Naradi petition is accepted, that a FR is accepted, my lord, and subsequently, my lord, if the complainant comes, then, my lord, my right interest, my lord.
you are not made a party here.
I'm not made a party and it is not mandatory, my lord. As on today, my lord, earlier, my lord, there are multiple examples.
But
before this office.
you are saying that you have a right of audience. Is
Yes,
that
my
what you're
lord,
trying
I
to
have
say?
the participatory right as on this
Audience.
stage, my lord.
All right, we
And
will
that
see you
also,
on
my
that
lord,
date.
I'll file an impleadment petition, whether I can
If
participate or not.
you have a
participate,
participatory right, you don't need any petition. All that is that you will be given an audience. You
Yes,
will
my-
get it.
Yes, my lord.
Why do you need
Only
an
that
IA
is
for that?
Straight for my lord.
Right.
That may be only accorded.
Only thing is there is a another concern, my lord. It's not obligatory to take. My
No,
lord,
he
make-
wants
Yes, my
to.
yes, my lord. He need not make me a party, my lord.
Let him
fairly
remain.
submitting, my lord.
So, but Mr. Vaidya, I'm telling you, it appears something is wrong. The way that officer has asked the informant, how can it be? You are also a criminal lawyer. One day you will be the other side standing.
Yes,
What
my
is
lord.
this?
My lord.
You all are officers of the court
we are
ultimately.
officer of court, my
How
lord,
can
and
the
it's my-
investigating officer direct the victims to go and collect evidences? Is that the job of the victims? What are the investigating agency for then?
Lord,
The only thing that the informant has to do is to inform. Thereafter, it is the job of government duty of the investigating officer to collect the evidences. I don't think this court needs to tell them how they have to do their job.
Lordship is very correct, my lord, on that regard, my lord.
So I am on that because you see, if that is so, then the order of the court below accepting that FR is patently erroneous.
Lordship, but there are other aspects.
We are
to
not
this,
going
my lord.
into that. You see, everything has to be there.
My lord, my lord.
A
my lord.
fair investigation, when will an investigation be fair? If everything has been looked into and a proper report is submitted, yes or no?
Yes, my lord.
Now, if a vital information is not being collected, is not looked into, and the FR is submitted, would that be fair?
Whether it is looked into or not, my lord.
Apparent. It is apparent. There was a notice given to you to produce.
Yes, my
Where,
lord,
which
I
page
had
is that?
given that lead, my lord.
Which,
I had given a petition, my lord. Your lordship kindly come to that, my lord. In respect of Redisham to another.
but
Where my
yesterday I
statement
think
has
I've
been
already,
second time, first time also and second time also, my lord. Page 77, my lord. No, sorry. 94, my lord. Then the police officer told me, yeah, that is my lord in the order also, my lord.
that I have seen,
Yes, my lord. That is
para
the,
15,
yes, my lord. Page 80.
the IO has categorically stated that during investigation, he
Yes.
could hardly gather any material that substantiates the ingredients of so and so. The IO has further stated that the petitioner victim failed to provide him with the footages of the alleged assault. Threat or wrongful confinement despite CCTV cameras being installed at the place of occurrence. Which is this place of occurrence? At Radisson Blue. Allegedly, it is the Radisson Blue Hotel at Goa.
Lordship, I'm not privy to all the documents.
No, I'm telling you. I'm telling you, this is what it appears. Heard Mr. NNB Chaudhary, learned counsel for the petitioner, also heard Mr. P.S. Lockor, learned APP for the state respondents. This matter was fixed today. After noticing that the investigating officer has, instead of collecting the crucial vital evidences, especially the CCTV footage of the place of occurrence, submitted the FR by stating that the victim stroke informant has not produced the same. Accordingly, this court directed the additional PP to produce the case record from the jurisdictional police station today. Today, however, Mr. So-and-so submits that the jurisdictional police station by letter dated 10/4/2025 has informed that that the case diary and all the related documents has already been submitted to the learned court of CJM.
CGM, no, special judge, Kamrup Metro Guwahati. Special Judicial Magistrate, Kamrup Metro Guwahati.
To the Court of Special Judicial Magistrate. But because this letter doesn't talk about,
They will submit to the CGM court. Thereafter, there will be.
Yes, Council.
correct,
CGM,
to the jurisdictional court of Chief Judicial Magistrate. Full stop. Mr. Chaudhary submits that the matter is presently pending before the court of.
Rana Special Judicial Magistrate.
I think that impugned
One
order will indicate.
Yes, my lord. Special Judicial Magistrate.
One sec, page.
Page, my lord, 79. 89, my lord.
Right,
79.
don't say submitted, huh? You simply say
89, my lord.
let the case records, including let the scan copy or
Scan copy maybe got.
no, I'm not staying. I'm not doing anything because it doesn't make any difference.
Because final report has been filed, my lord.
Correct. Let the case records be called for from the Court of Special Judge Magistrate Assam, Guwahati, Dispur.
There should be my Kamrup Metro should be there.
Okay, the special judge.
Special Judicial Magistrate.
Mr. Chaudhary, please ask your junior to just
Yes, my
put
lord.
it in a piece of paper and give.
Special Magistrate Kamrup Metro Guwahati.
Please don't make that, Mr. Vaidyan, Mr.
Yes, the
Chaudhary,
special
just give that
petition
name
is
because,
Assam
okay,
Tam-
you take it. Through the registry of this court.
It's in Tam Mohammed. They tell you. Tam Mohammed.
I think I can stay that order till
Yes,
then.
my lord.
74,
Yes, no, my page 89.
79. 79,
89.
89.
That is input order. My lord. My lord. 89.
List on such and such date. When?
Annexes.
Give a date on such and such date. Till the next date, the impugned order dated 4/3/2025 passed by the Special Judicial Magistrate Assam Guwahati shall remain stayed. And Mr. D. Vaidyan, learned counsel, by appearing has sought permission to address the court on behalf of the accused person, which is not opposed by Mr. NNV Chaudhary, learned counsel for the petitioner.
It is not obligatory, not on my part.
However, he submits that it is not obligatory on his part.
Yes, my lord.
However, it is not obligatory to implead stroke array the accused person in such petitions. Now, be that as it may, Mr. So and so is permitted to
Responded number.
no, he is permitted to submit written arguments on the next date of.
What you find impeded, not impeded.
No, I'm not impleading you.
I am not.
Participatory role is need not be impleaded.
Yes, sir.
You can address the court. Is at liberty to participate in the proceedings.
Lordship, if you sit on
Next.
28.
2084.
If you're ready.
I think that that yesterday's order I have already recorded it in detail. That is why I did not record
Yes, yes,
everything
yes.
today.
Make video launch. I have brought in the different, yes.
This is an NDPS.
This is an edit. I'll just,
Mr. Locker, I think similar rounds have been taken like Mr. Datta's case yesterday, I think. That
have-
is fixed tomorrow.
Lordship, I wanted the gist of everything. A little bit of submissions and the gist of dates and as well as the grounds for bail. I have given that, but one copy. Okay, take it.
You are challenging it on ground of 22(1), isn't it? That is one of your ground.
Which one?
Article 22(1) is that ground of arrest.
One is the ground
Because,
on basis of two
if-
specific ground.
If that
That is long inculcation.
Mr. Manan,
Yes.
if that is one of your ground, because another case of Mr. Datta is appearing in that, is fixed
Okay.
tomorrow specifically for that point.
Okay.
So can we have this along with that? Because there also that he took time, 2 days to address on the issue of Article 20, especially in context of an NDPS. Though that the other case of Supreme Court,
Here I am,
Vihan Kumar,
there are three
the,
cases.
the concluding part clearly says that statutory requirements in case there is a constitutional
Yes.
violation as regards not giving the grounds of arrest. No statutory bar will come in the way. It's very
Because-
clear. Anyway, you wanted to examine and that's how the matter was.
In fact, I have submitted one judgment from this court itself. This court is being,
I'll take it tomorrow
that is,
together, Mr.
that
Manan.
Vihan Kumar part has been specifically quoted and bail has been granted. My case itself, I am giving it that,
Very well.
as well as your lordship, some other judgments with regard to the other grounds that I have taken.
I'll have
taken
a
four
look at it.
grounds.
I'll have a look at it, Mr. Malan, and you
I
can
have
al-
also given him one copy.
give him also a
Yes, I have
copy, and
given him.
tomorrow, of course, I hear you also. In the meantime, let me go through
But it should be in the first half tomorrow. I have some
all right.
difficulty in the second.
কালি মাত্ৰটো কিমান নম্বৰত আছে এইটো চাই পেলাই let me fix it at 10:30.
No, I have no idea.
10:30, but tomorrow, otherwise, looks like, it, obviously the individual cases, you will have to show me from the case records or the diary, whether what has been communicated and whether that is sufficient or not, because that has to be seen. You see, Vihan Kumar, the apex code is very
I
clear.
will try to see.
It is not simply saying that, all right, there's an FIR pen, that you are being arrested because of some FIR. That will not be sufficient.
Grounds have to be disclosed.
It
in
has to
writing,
be disclosed and
In
in a
writing.
language,
because
the
it-
accused
some-
will
in some cases, Your
understand,
Lordship,
because it's not an empty formality.
in some cases,
uh,
Your Lordship, what happens, it is on the basis of the statement of co-ethics. That has to be stated that you have been arrested on the basis of this statement of the co-ethics. That should be recorded. That is the standard of the Lordship giving the grounds in writing.
There is a decision to that effect.
That
about the-
effect, there is no specific.
No, because,
In one of the
because
cases,
I understand what you're saying, Mr. Manan. At the end of the day, on what basis
yes,
a person is being arrested is what that person needs to know. Simply telling him that you're arrested because of contraband articles or something will
Yeah.
not do.
that is-
How you have connected, perhaps he's right. That is the main crux. That has to, because that, of course, you don't have to give a detailed, elaborate kind of a ground, but the main vital issue, why, that has to be there.
in my, I have already submitted the judgment of Prabir Pukasta, Vihan Kumar and Madhu Ray. The third is Madhu Ray. That is a judgment of this honorable court, where court has specifically stated that is actually I appeared in that case. That is why I'm taking that. In that, Your Lordship, there one more point was taken in my case in Madhu. That
One
was
second, one
memorandum of
second.
arrest,
I'm just taking that. You have given a lot of decisions.
because I have taken 4 grounds.
Acha, which one? Prabir Purkasta.
Prabir Pukasta, Vihan Kumar and Madhu Ray.
Prabir.
These are on the basis of this particular, Your Lordship. On the same,
Huh?
on the same line.
Same line.
Same line.
I have got Prabir Purkasta, Bihan Kumar, and which one you said?
Madhu Ray, this is our High Court judge.
Madhur Ray.
Madhu Ray.
Not getting that.
I can give one copy.
One second, no, it could be there. Just have a look. Hey, Borwa.
Then, a recent judgment, actually, I got it today. I could not. pick it up.
You give that tomorrow. If you have to give anything more, just have a look. I couldn't find it.
Ray versus the Union of India.
Vihan Kumar is
Very clear. Rehan Kumar, very clear.
on the basis of Vihan
You see, it will not vitiate the trial and charge sheet and all that. But here it is the question of arrest. You cannot detain someone by violating his fundamental constitutional rights. It is on that. And a statute cannot, because of the bar contained in the statute, how stringent it could be, that cannot curtail the, unless, no, it is specifically in case of prevention detention. It's a different thing. You examine that. I understand that anything, because these decision, Mr. Manan, any of the decision that you are citing today relates to an NDPS?
Yes, sir.
Which one?
What kindly take up?
Madhu
Madhurai.
Yeah, our house.
Actually, this, I think yesterday Mr. Datta had also,
It's actually I appeared in this.
yes,
That's why.
I can see.
Here,
so-
one
so
more,
it will be
one more actually point
To
was
have
taken.
you,
That is with regard to memorandum of arrest. In that case, a memorandum of arrest was given. But I have cited a judgment there that will not So that is also been.
You have none. Huh? You have none of Anit Kubur, kind of slip to. And the other, what is this Yusuf Asif?
Yusuf Asif is with regard to, your lordship, that is basically I have taken a ground that, yeah, non following the, procedure of search seizure.
That is NDPS.
This is NDPS, the others are all NDPS, except the one that is with.
The search and seizure, I have my reservation because there the factual, it's a question of ultimately facts. So which can also be taken up at the
There-
trial.
I have given a judgment of, Muhammad Muslim, that's there. In para 20 and 21, I have already stated, lordship will be, it can be seen from there. There, your lordship, the court specifically stated the lordship can go through all the records. And prima facie, if lordship is satisfied that the person may not be guilty, then bail can be. That was, otherwise, section 37, if it is followed in toto, nobody will be granted. So that is the reason I have given. If your lordship, it is not that I am going on merit or lordship will go on merit. Lordship, for the basis of the bail, whether these considerations can be taken into account and find out whether the person is guilty or not. When your lordship will see all the PWs, I have given a just gist of them. Lordship will read that. Can a person be convicted under such circumstances or such evidences? That is what, which are the reasons, and that is on what that ground I have given Asif versus Yusuf Asif. And which says that 52A is violated on the ground that the procedure of search and seizure has not been followed. And there is also a judgment of your lordship, where lordship has considered the PWs that I have given, considered the evidences of the PWs and found that he's not. Not specifically, but it is there. Apart from that, there was other grounds also.
That is the test. Whether
And that is why-
reasonably.
and one more
Only
thing, your
thing is
lordship,
when
very
a
important,
possession is proved, when it appears that it is from the possession, then
And-
that.
and one
counts.
more very important judgment that I have given, Justice Midul Polita's judgment. That is with regard to the rules, rules of 2022, search seizure rules under the NDPS, where it says that the violation of any of the procedure will amount to violation of section 52A of the rules. Therefore, it is mandatory. That is, I have given that. I've given the citations along with paragraphs here, but it can go through and find, can see that.
Yes, I'm just taking a note. Give him also a copy, Mr. Manna. Give a
I've given-
copy to.
I've given. I've given. And yesterday also, actually in the evening, I got a huge judgment of the Honorable Supreme Court, Justice Obay Oka and Ujjwal Bhuiyan judgment.
You have it?
This
You have it?
is with regard to, not with regard to this point. It is with regard to long inculcation, but there was a decision where the earlier order of the Honorable High Court was, it was rejected, and the second bail application was rejected without going into it. So it says, no, you have to go, because even if there is one, the evidences were taken, then also it is a changed circumstance. Your lordship asked me yesterday, what is the sense?
Yes,
I
because
said that
yours is a second bail. This case is a second bail application,
this is the second. bail.
which
It
is,
not
that-
saying
have
that
you
there is
given
a
that
change.
decision here?
No, I did not, I got it later on. I
Either-
can hand it over.
Yes, yes.
I can't do it. Huh? It is long interpretation of. It was nothing about-
And also about
the High
second,
Court has a second bail application.
and also on second bail application.
It says that it should, the High Court should have gone into the second bail application because the evidences have been completed. A short term. A recent judgment. It's of February 25th of February. Just for the sake of, may not be required. But even then, just.
First document is said, Thursday that, Yankuba judgment. It tells us then everything will go.
Many of the judgments are on the basis of long inculcation in my case. That's why there are so many judgments. The Supreme Court judgments, long inculcation has been considered in case even 1.5 years.
Eyewitnesses have been examined. This was a major change in circumstances brought up about after the dismissal of the first application.
In my case, your lordship, the witnesses have been examined, independent witnesses have also been. Not a single, I think, official witnesses examined till now. All the other independent witnesses have been examined,
And they have not
not implicated at all. And the
that's
standard,
examined.
and the standard your lordship will see, if your lordship goes to, will see the standard of evidence. Does not at all will be in a position to, your lordship convict a person. That, at least the petition. That is why I have just pointed. Okay, please continue.
List this bail petition tomorrow at 10:30 along with Ediyoku number 2. Along with we will not say, but you inform Mr. Datta
I'll
that
inform.
at 10:30 I'll.
Yeah, this matter will be taken
At
with his.
10:30.
Huh?
Some other matters are also there. All are still.
So you point out, but tell the councils because then if they are not present together, it will become difficult.
At least one decision will cover the other. Anyway, much obliged.
It is.
Order.
May please your lordship. Lordship, kindly fill his last order dated 28/11/2024.
Yes.
Last order lordship. 28/11/2024.
Report from the OC, jurisdictional police station. Death.
Regarding the
Who is
death of the
appearing for the
I'm
The
appearing
state-
for number one.
yes, Mr. Locker? The Thakur submitted that the report may also be from why from the why registry was directed to take
Lordship,
steps?
whatever I am for the petitioner lordship. Respondent number one informed that petitioner expired lordship, but I have tried to inquire lordship, but I could not.
No, but why registry? If it has to be from the police station, Mr. Locker can or Mr. Bothak.
Yes, he can also from the officer.
Report is already in the record.
Report has come. He died. So then it can be closed.
Can we close with the liberty if legal heirs will come? This is a proceeding under 145 lordship.
They are willing, petitioner is willing to withdraw the petition with a liberty because as petitioner is.
Why don't you make an attempt? Otherwise, you are not being able to.
Yes, lordship, I got the, or lordship kindly fix the matter immediately after vacation. In the
Make
meantime,
it-
try again lordship.
Heard Mr. MSP Bhattacharjee, learned counsel for the petitioner, appeal as a petition.
Petition.
Petitioner also heard Mr. A. Kalita, learned counsel for the respondent, and Mr. Swenso Locker, learned APP for the state respondent. The report as regards the status of the death of the petitioner has been as called for by this court by order dated 28/11/2024 has been received from the jurisdictional police station, which is available at flag X of the record. Perusal of the aforesaid report dated 13/2/2025 indicates that the petitioner expired on 25/7/2019 as per the death certificate. Stop, which is also enclosed with the report. Ms. So-and-so seeks a short accommodation to contact the family members of the petitioner to obtain necessary instruction in this regard. Prayer is allowed. List on such and such date.
Happy with, and there is the order dated 6/3/2020.
Reports were called for.
Yes, you have received.
Yes.
Sir, from the report, it reflects that, my lord, there is no such record in the police station, my lord. Police has submitted all the records along with the certificate, my lord.
Then what is to be done?
My friend requested me that although he has gone for the records, at that point that sometime he has not found that those records are there in the, my lord, LCR. He asked me to verify and check me again, my lord, in the record.
You verify.
I think they will have to again check the records for a bit to, because police has, well, from the report of the police, well, it reflects that, well, police has submitted all those records. There is no such record now in the police station. Police has submitted all those records at the time of filing of the charge sheet. So, well,
This is the criminal appeal.
whether that exhibit, well,
On the basis of that exhibit, he has been convicted.
But records have not come.
LCR is here.
So you verify.
I will have to again check.
I'll fix it on another date.
Yes.
Heard Mr. A.D. Chaudhary, learned D. Chaudhary, sorry. Heard Mr. D. Chaudhary, learned counsel for the appellant. Also heard Mr. P. Bhattakur, learned APP for the state respondent. Mr. Bhattakur, so and so submits that in terms of this court's earlier order dated 6/3/2025, whereby the exhibit, whereby the GD entry book, comma, first progress report, comma, exhibit 1 and exhibit 2 were called for from the jurisdictional police station. However, he has received a letter dated 26/3/2025, whereby the jurisdictional police station has informed him that why is this letter addressed to the honorable judge? Informed him that the case records and along with all the exhibits have been sent to the which court? To the jurisdictional? Sent to which court?
Was, conviction was, by
The trial court.
session judge.
To the trial court. To the trial court. Mr. Bhattakur submits that since the records of the trial courts are available in court, he may be accommodated to verify from the records as whether the aforesaid exhibits are available or not. Prayer is allowed. Lists, give a date or when you want, 12 and 32. Fix. None appears for the petitioner on call, relist. Did your date on such and such date?
Please, your lordship. Well, it on last occasion by Dhanak Singh was directed to obtain the up-to-date instruction, my lord.
But Bhattacharya, you are appearing, what is you appearing for?
Or Lordship, State of Mizoram, Lordship. Yes, for number 1.
Yeah. I'll not be able to locate.
Yes, that is the instruction I have.
How can it be? Then what is to be done?
I still requested them to try again, Lordship.
And I'm posting it after the vacation, you see what is to be done. What steps can be taken.
Yes.
Otherwise, it's becoming a very, not in this case, I'm not telling you, but in many cases, especially the old cases, very routine manner, it is being said from the jurisdictional police stations and all that the records are not available, missing.
Yeah, there is no stay order. Still, where,
So
how
it
the,
can't be, otherwise an inquiry has to be done, isn't it?
yes,
So you look
definitely,
into it,
definitely, Lordship.
you look into it, right?
In fact, Lordship, there one letter, Lordship, only the page 3, Lordship. That
Yes,
was
I've seen.
UP has written letter to the Lana district judge, Lordship.
Page?
Next, third page. Lordship.
This is going to be a serious thing because the stay was not
Exactly.
there. Heard, Mr.
And Islam.
M. Islam, learned counsel for the petitioners, also heard MSP Bhattacharya, learned additional Advocate General Mizoram for the state respondents. By order dated 18/3/2024, this court directed MSP Bhattacharya, learned additional Advocate General, to produce the up-to-date status of the trial. However, today when the matter is called, she produces a letter received from the Undersecretary to the Government of Mizoram Home Department dated 9/4/2025, whereby it is informed that upon the public prosecutor Mizoram having approached the district judge at the district court Aizawl, it has been learned that the current status of the case remains unknown due to the court's inability to locate the file and update it accordingly. So, the aforesaid communications are kept on record and marked as X. Before proceeding further into the matter, MSP Bhattacharya is given another chance to look into the matter and do the needful. List date May 2nd, 3rd. I'm giving you some time on such and such date. That since there is no stay order operating in the case, it is not the file, the case records being not located, not being able to locate. I think it's better not to say anything
Yes,
now.
Lordship. Let me try again.
We don't know what if this case is already over?
Yes.
We don't know what has happened.
Let me try once.
You try.
Yes, yes. I'll definitely try. Oblige.
Highly obliged. You try.
Here, the counsel of the other side is not seen.
Yes. Heard Mr. A.R. Sikdar, learned counsel for the petitioner, none appears for the respondent, private respondent.
16 my lord, conviction under Wildlife Protection Act, but the name of the my lord,
Okay.
Special Public
None appears for the special public prosecutor,
Wildlife.
wildlife.
His name may kindly be.
Wait. Yes. It appears that the name of the Learned Standing Council appearing for wildlife protection is not reflected in the cause list. Let registry reflect the name of Mr. You know his name?
Any name, my lord, B. Sharma.
B. Sharma is appearing.
Yes, sir.
The name of the B. Sharma, Learned Standing
Special
Council,
Special.
special PP, so and so. Wildlife protection. be reflected in the cause list. Relist after vacation, did you?
Development.
Thank you, Lordship. Lordship, I think Lordship had this matter earlier also, Lordship. This is a revision against conviction, Lordship. Under section 392, for undergo 3 years rigorous imprisonment, Lordship. And the Lordship judgment, Lordship, kindly come to page number 70, the judgment, Lordship.
Page number
17, Lordship.
yes.
Read, Lordship. I read,
This is against the judgment of against the conviction,
this, Lordship.
rash and negligent driving.
Yes. And this is the final judgment, Lordship. Page number 29, Lordship.
Hmm?
17.
Page number
29, Lordship, against which the revision has been preferred, Lordship.
Nirmala, can we have it after the vacation? Because there's 2 more I need to complete judgments which I had already dictated. Otherwise, if tomorrow is the last day for the vacation, it will be not possible.
After vacation,
Go to the detail. Third MSN as paid for MSN Nirmala, where copy to the petitioner. We list on such and such.
that's 20 also can it be after vacation?
Yes, let's wait for Polder. Give a date.
So there is interim order.
Interim, if any, shall continue to the next date of first.
Okay.
Mr. Roy,
But we have come against the offense report, my lords.
special PP is there, I think.
It will be forest, my lord.
Not there.
We'll have to inform.
Mr. BK Mahajan is also special PP.
Earlier he was there.
Oh, then I think, because the name is not shown. Special PP for forest,
Forest,
wildlife.
wildlife.
Third, Mr. J. Roy, Learned Senior Counsel, assisted by Mr.
PP Sharma.
Huh?
PP Sharma.
D.P. Sharma, Learned Counsel for the petitioners, also heard P. Borthak, plan appears for the respondent on call. It appears that the name of the standing council, forest, wildlife and forest is not reflected in the cause list. That's the special PP. Let the name of Mr. D. Sharma, let special PP for so and so be reflected in the cause list on the next date of listing. List. What do you want?
Maybe in the month of May, my lord,
All right, did your date?
20 May.
And Tatek Waiting that it appears that the name of Mr. BK Mahajan is reflected in the cause list as special PP. However, it is submitted in the part that he is no longer
Special.
holding the set post. Tarpisat let registry.
Public.
Yes. 24.
The last date lost to public procedure has some more time.
The Parasar have taken time for the case diary was not there. I can see Mr. Parasar is here now. Do you have it? Huh?
But
After vacation,
we've sent the signal, but
you will send the,
we've sent the signal on the same day, but
oh yeah, I've not understood.
we have sent the signal from our office, to the, but today receiver not for that information I have.
Mr. Heard Mr. L. Mohan, Learned Counsel for the petitioners, also heard Mr. K.K. Parashar, Learned APP for the state respondent. Mr. Parashar, Learned APP submits that though the jurisdictional police station has been instructed to send the case diary as called for by this court earlier. However, today he is unable to, however, the information as whether the set has been received by his office or not is not available at this moment. That being so, relist on such and such date to enable so and so to place the case diary as called for earlier. Yes,
Absent for today, and guest council is not able to pay up.
all right.
State in disposal is already there. After we fix it.
Heard MSR Chaudhary, Leonard Amicus Curie, also heard Mr.
I'm not a Michael.
Coenso for the petitioner, also heard
I am alone.
M. Alam,
If
here Leonard Counsel appearing for respondent,
Number two, Lordship.
respondent number 2.
One is PP.
And Mr. Robert Thakur, PP, if for the state AP, state respondent. Mr. A. Alamgir, Leonard Counsel for the respondent, seeks a short accommodation in the matter. Prayer is not opposed. Relist
fix it in what's it?
8 May.
Obliged.
Yes, Mr.
Hello.
Dekka,
My lord,
Ms. Diane,
my learned friend is, agreeing, Lord, I'm taking some time, I'm not feeling well when today, Lord.
all right.
Any day after
Because
vacation.
we have already.
Yes,
taken
yes.
argument already.
Yes, yes. As prayed for by Mr. P.K. Dekka, Leonard
Hello.
Counsel for the petitioner, which is not opposed by M.S.A. Gain, Leonard, you're appearing as standing counsel,
AED, yes.
Leonard Standing Counsel, CD, relist on such and such date.
After
In my.
22,
Did you?
20. 20.
My lord, in my case, there is an interim order. there.
Interim if any shall continue to the next date of listing.
Yes.
Obliged.
Master.
None appears for the petitioner on call. None appear for the none appears for the petitioner. Um, Private counsels are there, isn't it? They are there. Okay. Mr. Bothakur APP is present. However, there is no appearance on behalf of the private respondents. You are there? Okay, okay. His name also you put.
Yeah.
Item 31.
31. Kindly pass over for a time being. My senior is on.
All right,
leave.
another date then. This is the last matter. Heard MS.
KLR Yanthan.
So and so, Leonard Counsel for the petitioner and
Yeah.
what Ahmed?
Yeah.
A. Ahmed and Bothakur as paper list immediately after vacation.